Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal lawsuits to enforce the USCIS Form I-864 Affidavit of Support. One of the questions that how conditional residency works when it comes to lawsuits to enforce the Affidavit of Support. It's really common to be on their 2-year conditional residency status. And there's often concern about whether they are going to lose the right to enforce the affidavit of support as they try to transition from their 2-year conditional residency status onto their 10-year renewable non-conditional residency status. That's understandable, but the bottom line is that that concern is misplaced. Conditional residency status to unconditional residency status simply does not impact that. But even if your I-751 petition is denied, that doesn't abolish your right to enforce the affidavit. Why? When do rights under the affidavit of support begin? Well, the statute is very clear that your right to financial support under the affidavit of support starts once you acquire resident status based on an application that included the affidavit. So whether you go through adjustment of status or get an immigrant visa and arrive in the United States, either way, once you get status based on that process, that's what starts your right to financial support under the affidavit of support. That is true even if the status that you get, the residency status, comes with conditional status. Recall that 2-year conditional residency status is what you get if you get status based on a marriage that's 2 years or less in duration. So conditional or unconditional, it doesn't matter. Once you get residency based on an application that included the affidavit of support, you have the right to receive financial support to maintain your income at 125% of the federal poverty guideline. Now, what ends the right to financial support under the affidavit? Well, there are 5 different terminating events. The one that is important to this is that loss of residency and departure from the United States terminates the affidavit of support. So let's say that you get to the end of your 2-year conditional residency status and you file the I-751 and it's denied. Does that terminate your rights under the affidavit? No. Why not? Because only loss of residential status and departure from the United States terminates the affidavit of support. So even if USCIS denies the I-751 and you've lost status as a resident, that doesn't end your entitlement to support unless you subsequently depart the United States. And what usually happens when USCIS denies the I-751, the person will be served a notice to appear and will have a chance in removal proceedings to reassert the I-751 in deportation defense. But again, regardless of whether the person is successful in doing that, the I-864 Affidavit of Support remains enforceable. So on that worst case scenario, where the person comes up on the 2-year status expiration, files the I-751, and it's denied, it doesn't matter when it comes to the affidavit of support because it's not terminated and it's still enforceable. The reason Congress probably wrote the statute and had it interpreted as it was by what was then Immigration and Nationality Services, the reason that it's interpreted that way is that the whole purpose of the affidavit of support is as an insurance policy to make sure that sponsored immigrants have a way to be financially supported while they're in the US. So it was reasonable to think that you would want that affidavit of support to remain enforceable, even if the person loses residential status, because as long as they're in the United States, the whole purpose of the affidavit is that during the enforcement period, the onus is on the sponsor to provide financial support rather than making the person dependent on public benefits. So that's why even if the I-751 is denied, it doesn't matter. The I-864 remains enforceable as long as the person is present in the United States. So you can imagine that if straight denial of the I-751 doesn't result in loss of rights under the I-864, it certainly doesn't end your rights under the I-864 if you get the I-751 approved based on a waiver. Remember that the I-751 is customarily filed jointly with the participation of the U.S. citizen. So typically it's the foreign national green card holder plus the U.S. citizen's spouse who file the I-751 together. But it's really common when folks are going through a divorce, which is often when the I-864 comes up, that the U.S. citizen spouse says, hey, I'm not going to file the I-751 with you. You're on your own. The foreign national can still proceed with the I-751 based on three different conditions, three different strategies. One of those being good faith marriage that was ended in divorce. The other common one being abuse by the U.S. citizen spouse. You can still, as the foreign national, pursue those waiver strategies, and it doesn't abolish rights under the I-864. Because again, only loss of residential status and departure from the United States ends rights under the Affidavit of Support. But both green card holders who are considering lawsuits under the I-864 and also defense attorneys both get hung up on this idea that somehow in transitioning from 2-year conditional residency status to unconditional residency status, there's something in there that terminates rights under the Affidavit of Support. And that's just not right. There's nothing in the statute that supports that view. One reason that I believe this creates confusion is that I've heard this from defense attorneys before. They say that going from 2-year conditional status to unconditional status, especially if it's based on an I-751 waiver, is a change of status. That's just completely incorrect. So change of status and adjustment of status are both terms of art under the Immigration and Nationality Act. Change of status refers to going from one non-immigrant status to another non-immigrant status. Adjustment of status is when you acquire U.S. residency in the United States based on an I-485 application. And that's just not what happens going from 2-year conditional residency to unconditional residency. When you look at the title of the I-751 petition, what it says is it is a petition to remove the conditions from your residential status. So you're not acquiring a new residential status. You're simply removing that asterisk, that conditional nature, from your existing residential status. That's all rather hyper-technical, but the bottom line is that you're not acquiring a new status. You simply have that original status, which is important because that original status is the one that gave rights to the Affidavit of Support. So bottom line is that whether you file the I-751 together with your U.S. citizen spouse, whether you file it as a waiver, and even if it's denied, under any of those three events, you as the foreign national still have rights to enforce the Affidavit of Support because those rights commenced when you became a resident. They don't end until you lose residency status and depart the United States, along with the other 4 reasons that are enumerated in the Affidavit of Support. But when it comes to the I-751 petition, as a joint petition, a waiver petition, or just denied, it does not matter, and the foreign national still has rights under the Affidavit of Support. This is true, again, even if USCIS denies the affidavit and the person is in removal proceedings. So they can be in active removal proceedings before EOIR, which is the Executive Office of Immigration Review. They can be in deportation court and still have rights to financial support under the Affidavit of Support. So I know a lot of foreign nationals are confused about this. A lot of defense attorneys at least pretend to be confused about this issue, but it's actually not that complicated at the end of the day. Hope this is helpful. If you have questions or you want citations to authority for what I've described here, feel free to jump into the comments. If you would like an individualized case assessment of your rights under the Affidavit of Support, feel free to reach out to me. We do free Zoom consultations all across the United States. Hope that's helpful. Thanks, folks.